Case 5. Rowe, the plaintiff, versus New Hampshire Motor Transport Association, the defendants. We find ourselves in the Supreme Court of the United States. The facts. Rowe is about implied preemption and is valuable insofar as it is one of the leading and recent decisions on the matter by the Supreme Court, and is instructive even if it is not about the Airline Deregulation Act precisely. Here, the state of Maine has codified a statute that regulates the delivery of tobacco to customers within the state. More specifically, the state has adopted an act to regulate the delivery of tobacco products and to prevent the sale of tobacco products to minors. The policy underlying this law is largely uncontroversial. Keeping cigarettes away from minors is a good thing. But courts are duty-bound to apply the law, and here, however much the court might like the policy and purpose of Maine's law, the law runs afoul of the Federal Aviation Administration Authorization Act of 1994. That's a mouthful. We'll call it the F4A from here on out. The F4A does not explicitly preempt the two provisions of the Maine statute at issue, that is, a recipient verification provision and a deemed to know provision detailed below. That means, as is so often the case in preemption cases, that the court must divine the intent of Congress. In all, this case should create some dissonance for you. The cause is right, and yet Maine loses in court. How can that be? It is because courts must apply the laws as written by Congress, and if Congress has written bad, not unconstitutional laws which a court can strike down, it seems that a legislative fix is the only solution. This will all come into play as you dig deeper in the Airline Deregulation Act case. So what is the issue? Whether a federal statute that prohibits states from enacting any law related to a motor carrier price, route, or service preempts two provisions of a Maine tobacco law, which regulate the delivery of tobacco to customers within the state. The holding of the case. The court held that the federal law did indeed preempt both provisions. Let's dive into the reasoning that led to this holding. Let's first look at the Motor Carrier Act of 1980, and then Maine's Act to regulate the delivery of tobacco products and to prevent the sale of tobacco products to minors. In 1980, Congress deregulated trucking by enacting the Motor Carrier Act of 1980. And a little over a decade later, in 1994, Congress similarly sought to preempt state trucking regulation. In doing so, it borrowed language from the Airline Deregulation Act of 1978 and wrote into its 1994 law language that says, "A state may not enact or enforce a law related to a price, route, or service of any motor carrier with respect to the transportation of property." The state of Maine subsequently adopted an act to regulate the delivery and sales of tobacco products and to prevent the sale of tobacco products to minors, two sections of which are relevant here. The recipient verification provision. The first section forbids anyone other than a Maine licensed tobacco retailer to accept an order for delivery of tobacco. And it then adds that when a licensed retailer accepts an order and ships tobacco, the retailer must utilize a delivery service that provides a special kind of recipient verification service. The delivery service must make certain that, number one, the person who bought the tobacco is the person to whom the package is addressed. The person to whom the package is addressed is of legal age to purchase tobacco. The person to whom the package is addressed has himself or herself signed for the package, and the person to whom the package is addressed, if under the age of 27, has produced a valid government-issued photo ID with proof of age. Violations are punishable by civil penalties. First offense, up to $1,500. Subsequent offenses, up to $5,000. Second provision, the deemed to know provision. The second section forbids any person knowingly to transport a tobacco person to a person in Maine unless either the sender or the receiver has a Maine license. It then adds that a person is deemed to know that a package contains a tobacco product. If the package is marked as containing tobacco and displays the name and license of a Maine licensed tobacco retailer, or if the person receives the package from someone whose name appears on a list of unlicensed tobacco retailers that Maine's Attorney General distributes to various package delivery companies. Again, violations are punishable by civil penalties, $1,500 for a violation against the violator and/or the violator's employer. The majority opinion of this court found significance in the fact that the state law was not general and did not impact trucking in a tenuous, remote, or peripheral way. Let's elaborate on that. The Supreme Court noted that the Maine law was not general. It did not affect truckers solely in their capacity as members of a general public. Instead, the impact was significant, and the connection with trucking was not tenuous, remote, or peripheral. Rather, the state statutes aimed directly and specifically at the carriage of goods, a commercial field where carriage by commercial motor vehicles plays a major role. The state statutes required motor carrier operators to perform certain services, thereby limiting their ability to provide incompatible alternative services. And they do so simply because the state seeks to enlist the motor carrier operators as allies in its enforcement efforts. Given these circumstances, from the perspective of preemption, this case is no more borderline than was Morales, the court says. Given Morales, where the court held that federal law preempts state consumer protection laws, the Supreme Court found that federal law must also preempt Maine's efforts directly to regulate carrier services. In her concurrence, Justice Ginsburg noted that the court was bound by the language of the F4A and the precedent established in two Supreme Court decisions, Morales versus Trans World Airlines and American Airlines versus Wolins, which she authored. As a result, the court is constrained to fill the large regulatory gap left by an application of the F4A, perhaps overlooked by Congress. Let's look at it from her point of view. While I join the court's opinion, I doubt that the drafters of the F4A, a statute designed to deregulate the carriage of goods, anticipated the measure's facilitation of minors' access to tobacco. Now, alerted to the problem, Congress has the capacity to act with care and dispatch to provide an effective solution. The bottom line here is that the court may want to do something in this case to make the situation right. It might want to say something like the concepts in the Maine statute are exempt from the F4A, but the court is prohibited from doing so. Only Congress can pass such a law. This is an example of judicial restraint and is an excellent illustration of the judicial and legislative branch staying in their own lanes. But how inefficient is it to have to now go back to Congress after all the money and time litigants have spent to show the court that there is indeed an unintended and undesirable consequence created by the F4A relative to tobacco sale to minors? Alas, that is democracy in action, and the US Constitution operating as designed. Okay, so we've heard from Justice Ginsburg. Now let's hear what Justice Scalia had to say in his concurrence. He joined the opinion of the court except those portions that relied on the reports of committees of one House of Congress to show the intent that full House and of the other with regard to propositions that are apparent from the text of the law unnecessary to the disposition of the case or both. In other words, Justice Scalia, true to his reputation, rejected the notion that anything other than the text of the statutes and laws in question were necessary or appropriate for disposition of this case. An interesting and sometimes controversial judicial philosophy.